Well, thank you very much for the introduction. I appreciate that. It's really quite a delight to come back to Western and be here. I've got many, many fond memories of being around this place, even this room. So it's kind of fascinating. I'll mention one in a couple of moments that will perhaps interest you. But a great spot to be. I'm a graduate of this school, as you've learned. But I'm also here with my dear wife, who's a graduate as well. We met here at Western. That's what happens when you come to these schools, you know. And somehow she still stayed with me all this time. And my law partner by 1972, Bob Wood, sitting over in the corner here, managed to get through this school with good marks. And we formed a partnership called Walker and Wood in 1972, and to this day it still carries on as Walker and Wood. Fortunately, without me, but he does seem to carry on very well. The school, this whole room, of course, is dedicated to Ivan Rand, whose wonderful portrait we see down in the main foyer. And Ivan Rand was that magnificent Supreme Court judge in Canada who came here after he retired at age 75 and started the first law school in 1959. And I happened to meet him as I was going through arts because I was involved with the model parliament. That probably doesn't come as a surprise. And anyway, he became a speaker in the sense of moderating the fractious House of Commons that we had over in Convocation Hall. And Ivan Rand was a fascinating person. He just, I don't think he ran the school particularly well, but he sure was a wonderful inspiration for everybody. And people sat and talked with him, and he's the one that convinced me I should come to law, so I did, and kind of surprised myself. I got onto the Dean's Honor List in the first year, but it went downhill after that. But I think there are reasons for it. Guy has mentioned that I became an alderman in the City of London, and you had to have white hair back then to become an alderman. I would only now qualify for that job, but I became an alderman when I was in my third year of law school. That's in part why it went downhill after that. It took anyway, I got through, but the aldermanic career was interesting because no one had ever knocked on doors to win an aldermanic contest. But the lawyers were capable of being persuaded that way, and so my law class of 50 people, 90% of them turned up, and we knocked on doors one day, closing in on December when the election was happening, and I ended up getting elected and went through 2 terms of office. I asked the dean, his name was Fred Crothers, A.W.R. Crothers. I asked him if I could do this. I think he thought it was a joke and figured, well, sure, yeah, go ahead. Yeah, it's a good experience for young students, you know. Well, I suspect he was rather surprised that night when he was listening to the radio and heard the results broadcast. So that was kind of an interesting period of time. I don't know how the faculty quite took me after that. I had some fun with some, and I had some difficulties with others as they challenged me on certain things. But it was interesting. The Moot Courtroom, of course, is a very memorable place. I was here before. I've been here many times before when I was a student. Now, it wasn't quite the same as this. You see, it was theater-style seating, and nice. I mean, it could have been right out of a downtown theater, and rugs through all the floor. Imagine that. Rugs up here, rugs under the bench. I remember fighting a case here in Moot Courtroom. I don't think I came out on the right side of that one, but anyway, it was good experience. That wasn't the only time I was into the Moot Courtroom. I often came into the Moot Courtroom. However, it was more or less in the afternoon around 2 o'clock, and I could crawl under the bench and have a snooze. And it was rugged all through the place. It was very comfortable, very dark, and you know, no one was using the courtroom. Except one day the dean came in with some ladies in tow. I think it might have been Mrs. Spencer Niblet and a few others, but in came the dean to show them around. And I didn't really know what to do, but I shrunk beneath the bench as much as I could. And I could see him wandering around with his legs. That's all I could see, legs on the one side and the ladies looking. But they never looked far enough under the bench to see me. But I often thought how interesting it would have been if I had sort of stood up at that moment and walked out and excused myself. Anyway, I didn't. So I stayed, and it worked out well. So great to be here. Great to come and talk to you, to be part of the Cusley experience. I've been calling that Cusley, so the Cusley experience. And I know of the good work that it does, and the two sides of the border attempting to come together and present sides of law that relates to the relationship between Canada and the United States. So I indeed consider it an honor to be invited here to be part of this 7th annual lecture, distinguished lecture they call it. I don't know what makes it distinguished, but I guess the fact that they just call it that. Western School of Law did shape my career a great deal over the past 5 decades, whether it was the practice of law or the making of law or the administering of law. And so there's not a day that goes by that I do not have somehow or another a use to be made of the basic grounding that I learned here at Western Law. Perhaps I even helped to shape something of the university itself, because when I was MPP, the University of Western Ontario Act came up for renewal and revision, and I was very much a part of redrafting that, and for 10 years it carried my name on it as the University of Western Ontario Act as the sponsor in the legislature. The purpose of the Canada-United States Law Institute is identified as serving as a forum for the exploration and the debate of legal aspects of the Canada-United States relations. If one were to look for a case study to best examine the relations between the two countries, then you need look no further than the Boundary Waters Treaty Act, the Boundary Waters Treaty of 1909. That particular treaty established the International Joint Commission on which I serve. Now, the title of this lecture is The Boundary Waters Treaty 1909, a Peace Treaty. With that title, I pose the question of whether the Boundary Waters Treaty is a water treaty per se or a peace treaty. Before I get into the treaty itself, I think we need to be clear on what constitutes a peace treaty. The common understanding is that a peace treaty contains provisions to end hostilities between two nations by resolving the issues that led to the conflict in the first place, as well as providing for the resolution of future conflicts before they escalate into reopening of the hostilities. In short, an effective peace treaty should be both of these: end the conflict and keep the peace. And so, with that, I'll set out my general thesis for this paper, mainly that the BWT, the Boundary Waters Treaty, has been for over 100 years and continues to be a model agreement between two nations for the prevention and resolution of disputes. I think it would be useful to have some historical context to play out this argument. Water and water rights have been important and enduring issues, long-standing, and generally for this amicable relationship between Canada and the United States, going back as far as the American War of Independence. A number of treaties preceded the Boundary Waters Treaty and are worth mentioning for their context. The definitive Treaty of Peace, concluded in 1783 between Great Britain and the United States, recognized that each country had jurisdiction over waters on its own side of the border. And during the following century, Great Britain and the United States concluded several treaties to resolve disputes, all with provisions relating to the use of water flowing along, across, and over the boundary, particularly for navigation. The most notable ones included In 1794, the Jay Treaty, which, although mostly known for Article 3, which allowed First Nations Americans to travel back and forth, crisscrossing the border. The Jay Treaty was first negotiated between the U.S. and Britain to settle those leftover disputes arising in the U.S. Revolutionary War, and it bought about 10 years of peace. And then there was the Rush-Bagot Agreement, which demilitarized the Great Lakes and Lake Champlain. And in 1871, the Treaty of Washington, which settled the dispute over the location of the Pacific border in the Straits of Juan de Fuca. It was the first border dispute in the world to be settled by arbitration, with the arbitrator appointing a three-person committee to determine the facts and recommend the solution. Now, as an aside, I have to tell you that Britain almost didn't sign that treaty. It finally only agreed after its insistence that they would not sign a treaty that contained a split infinitive. Now, of particular note, for purposes of this discussion, is the International Waterways Commission, which operated officially between 1905 and 1913. Of which I will speak in more detail in a few moments. But first, let's look at what is encompassed in the Boundary Waters Treaty, some of which you've seen posted on the screen behind me a few moments ago. Now, the words Boundary Waters Treaty and Boundary Waters seem succinct, indeed seem very easy to say. But for Canada and the United States, the boundary waters are in proportions that are unparalleled in the world. Boundary waters are those waters which cross the boundary or which make up the boundary. There being some very obvious examples like the Great Lakes and the St. Lawrence River. But even these proportions are gargantuan. They are huge. 1,500 miles from one end to the other. 40% of the boundary bisected by lakes and streams and rivers. 20% of the world's fresh water in these Great Lakes. In places, the Great Lakes are more than 1,000 feet deep, and other places just a few feet. But those lakes are not our only boundary waters. The boundary waters encompass 300 lakes and rivers across, along, and over our common border, from the Bay of Fundy to the Straits of Juan de Fuca to the Beaufort Sea in the north. With 10,000 miles of coastline in our Great Lakes, and with a border the full length, the possibility of issues between these two countries abound. When we think of Great Lakes, we must keep in mind that the basin of the Great Lakes, the basin, or the watershed, is really part of the same territory. And this basin is so big that it's larger than several European countries. Economically, if it were looked at, it would be equivalent to the 8th largest economy in the world. The Laurentian Great Lakes, as they're sometimes referred to, are truly an ecological and economic powerhouse in the heart of North America. In fact, here we are today. The Thames River is right beside us. One of those amazing tributaries coursing within a few hundred feet of where we are, traveling all the way to Lake St. Clair and some 200 miles from the top end to the delta. We all drink Great Lakes water. In fact, 40 million people a day drink the Great Lakes water. Even if they take it from a plastic bottle, it's from the Great Lakes. Lake Huron water is piped right out here to the fountain here in this institution. We stand in the watershed of Lake St. Clair, and yet 10 miles south of us is the watershed for Lake Erie, and 10 miles north of us the watershed for Lake Huron. If we measured all the groundwater that's located in this basin that's called the Great Lakes Basin, if we measured all of that groundwater, it would surpass all of the water in Lake Michigan. And that's a very, very deep lake. The Great Lakes Basin encompasses 8 states of the Union, 2 provinces of Canada. Now that is just part of the domain of the International Joint Commission, though it's a big part. The other 300 lakes and rivers across Canada, basically, these begin in the Far East at the Passamaquoddy Bay, where the St. Croix River is located, and they travel all across the country. We could pick up the Richelieu River as part of Lake Champlain, the Rainy River after we clear the Great Lakes, the Rainy River and Lake of the Woods for Ontario and Minnesota basins, the Red River in Manitoba and North Dakota, the Souris River beyond that, and the Columbia in British Columbia and Washington, and even stretching up to the Yukon River in Alaska. It's wonderful that we have 5,000 miles of border that's undefended. But you know, it hasn't always been that way. There was a time when there was open conflict between our nations. 200 years ago, this month, 200 years ago, the peoples of Canada and the United States were locked in a war over many, many things, but it was largely border. This very month, October 5th, 1813, the Battle of the Thames, not 50 miles from where we are here, in a place called Moraviantown. Well, a lot of things happened. At that point, the British got routed out, and the Americans took over southwestern Ontario control. General Harrison was the victor, the American general. He went on to be president. And remember, Tecumseh died on the great Indian chief died on the battlefield there. The British general, the Canadian militia, and all the regulars fled along the Thames right back here to London, to the forks of the Thames, where we are today. But that wasn't the only battle. There was another one a little later in October where the British were very successful. They were very successful in the Châteauguay, Quebec, just southwest of Montreal on October 26th. That's 200 years ago last Saturday. A great victory there. 300 of the forces, militia and regulars, defeated 3,000 men, saving Montreal. This was the great victory of de Salaberry. But the war was seesaw, back and forth, and stalemate is most frequently the description of the outcome of that war. At the end of the war, the two countries each had an awful lot of respect for each other, but the border remained the same. In that war, 3 countries were involved. Great Britain, of course, Canada as its colony, and of course the United States. I mention these countries because 100 years later, the same players were at it once again: Britain, the United States, and the Dominion of Canada. Admittedly, 100 years ago today, the relations were getting better, but they still weren't perfect. In the decade before, the relations amongst those 3 countries were on tenterhooks. The United States and Britain, well, they were getting along pretty well. In fact, Britain was making nice to the United States at that point in time, and did for a number of years, as attempted to counteract the impact of the growing arms race with Germany. Yet by the turn of the century, Canada still had its problems with the United States. Britain was Canada's protector, indeed its only voice on the world stage. There was no Canadian capacity for foreign affairs. There was no Ministry of External Affairs. There was no one in Canada that could do anything about that. Canada was just 30 years old at that point, and remember, it had been a country that had been knitted together as a string of British colonies stretching across 5,000 miles, connected by nothing more than a line on a map and the Canadian Pacific Railway. There weren't very many people living in between. And Canada had come together largely to thwart the northern expansion of the United States. It being noted that on the very day that Canada became a nation, July the 1st, 1867, it was the very same day that Alaska was purchased from the Russians. The American Secretary of State, Seward, who always intended to enlarge the U.S. frontiers, had now bookended Canada with states to the south and a territory called Alaska to the north. At the turn of the 20th century, there were issues that were causing friction, indeed, which might have led to war. For one, there was the Alaska Panhandle dispute, a border question between Canada and the U.S. over a position of a line along the Alaska and BC border. It had not been resolved since the days of the Russians. This narrow strip of no man's land suddenly took on great proportions because of the Klondike, the gold rush in 1898. Now, it was of interest to both, and it was a question of whether this line and demarcation would be along one set of mountains or along another set of mountains. Not a very big issue, one would think. It was no man's land. However, it led President Teddy Roosevelt to threaten to send in the Marines if the U.S. did not get its way. And having been late of the Spanish-American War just a few years earlier, where he made his name winning that battle with Marines, he was certainly not to be ignored. He even threw out that line about walk softly and carry a big stick, a phrase that certainly caught the attention of Canada, now led by Prime Minister Sir Wilfrid Laurier. And other issues. There was the question of the Milk and St. Mary River in Alberta, Saskatchewan, and Montana. The Americans dammed up one river and built canals for irrigation. The Canadians retaliated by starting to dig their own canal and dams on the other side. Well, it escalated to the point where many thought it would lead to violence. Disputes over other waters were developing as well. On the Niagara River, diversions for electricity were threatening the scenic beauty of Niagara Falls. On the Rainy River, near Lake of the Woods, there was conflict over what should be the proper water level for navigation, hydro production, and farming. Of course, when it comes to water level, one level size does not fit all, and so the conflicts continued. For Canada, the diversion of Lake Michigan water at Chicago was another concern. The Canadian government was troubled at the prospect that unilateral action on the part of the U.S. to divert more water out of Lake Michigan that would lower Lake Huron would have economic impacts in terms of lost revenues, generating hydropower at Niagara Falls, and necessitate lighter loads for the shipping industry. Somehow it didn't seem fair nor equitable. Even though Lake Michigan is the only Great Lake that's located wholly within one country, United States, presumably Canada should have something to say about the diversion. For if Michigan had lower levels of water, that would affect Lake Huron, as they're one and the same lake. These are just a few examples. In fact, there were conflicts developing all along the boundary waters between interests in Canada and the United States. So the question was what to do to resolve the conflicts and maintain peace between us and along the border. By 1906, the Americans were quite impressed with the formula that they used to solve the Alaska Panhandle dispute, though conversely, Canada was quite annoyed. Nevertheless, the formula for solving the dispute with 3 commissioners from each side seemed to work, except for the fact that the British judge sided with the Americans and tipped the balance of power to the annoyance and, in fact, the anger of Canadians. The formula, however, was good, so it would seem. In the event, the Canadians were far angrier with the British than they were with the Americans even, for Canada expected Britain to take their side. But Britain was now putting foreign policy vis-a-vis the U.S. before the interests of Canada. In the end, the 3 countries saw value in a treaty to address these boundary water disputes that existed, and also the ones that would invariably arise. Though at the time Britain was still handling all the foreign affairs for Canada, it was holding back and letting Canada do its own negotiation, which it did, largely with the intervention and work of a local person from here in London, Ontario, strange as it might seem, Mr. George Gibbons, a lawyer. He had the ear of Prime Minister Laurier. That was Canada's negotiating team, its Foreign Affairs Department, run from a law office down on King and Richmond Street. His U.S. counterpart was none other than the renowned Secretary of State, the Honorable Elihu Root, who had been a U.S. presence ever since the days of the Civil War. And he, of course, had the ear of President Roosevelt. George Gibbons was well known to this university. He was a member of the Board of Governors at the very time that he negotiated this treaty. Gibbons was also the chair of the predecessor organization to the International Joint Commission that was called the International Waterways Commission, which failed in its decade of existence, failed ever to resolve a single dispute. In fact, it operated on instructions from government, and its members had no authority to negotiate. It was that experience that convinced Gibbons that only an independent body made up of plenipotentiaries, only they could resolve the thorny issues that extant. And in fact, the treaty, actually in its appointment of the commissioners, states, "Each commissioner shall make and subscribe a solemn declaration in writing that he will faithfully and impartially perform the duties imposed upon him under this treaty." These men, Gibbons and Root, cobbled together the treaty in what became the last of the Empire treaties. Great Britain was not prepared to give too much latitude to Canada, but it would allow Canada to negotiate, but Canada would not sign. It would be Britain that signed the treaty. The fact is that a treaty in Canada, an Empire treaty, is very significant. In the U.S., by virtue of being a treaty and being approved by the U.S. Senate, it binds the states. In Canada, by virtue of being an Empire treaty, it binds the province. Under Section 132 of our Constitution Act, 1867, the federal government has the authority to implement treaties entered into by Britain on Canada's behalf. The treaty itself is very elegantly written. The United States of America and His Majesty the King of the United Kingdom of Great Britain and Ireland and the British dominions beyond the seas, Emperor of India, being equally desirous to prevent disputes regarding the use of boundary waters and to settle all questions which are now pending between the United States and the Dominion of Canada involving the rights, obligations, or interests of either in relation to the other or to the inhabitants of the other along their common frontier, and to make provision for the adjustment and settlement of all such questions as hereafter arise, have resolved to conclude a treaty in furtherance of these ends. Consider now, on a closer read, how the preamble supports the thesis that the Boundary Waters Treaty is really more a peace treaty than a water treaty. The parties are resolved to conclude a treaty, being equally desirous to prevent disputes regarding the use of boundary waters and to settle all questions which are now pending and to make provisions for the adjustment and settlement of all such questions as hereafter arise. So in short, the purpose of the treaty is really to establish and keep the peace over the two nations' shared boundary waters. The BWT contains a number of articles to keep that peace. It was designed as a mechanism to protect each side from the other, to resolve disputes and to solve problems, mostly relating to boundary water, particularly matters relating to water quality and water quantity. Using the word pollution, for perhaps the first time, a very far-sighted move. So how does the Boundary Water Treaty keep the peace? First, in the preliminary article, it defines the boundary waters so as to limit the disputes as to what waters are and what are not subjected to the treaty. Boundary waters are defined as the waters from main shore to main shore of the lakes and rivers and connecting waterways, or the portions thereof, along which the international boundary between the United States and the Dominion of Canada passes, including all bays, arms, and inlets thereof, but not including tributary waters which in their natural channels would flow into such lakes, rivers, and waterways, or waters flowing from such lakes, rivers, and waterways, or the waters of rivers flowing across the boundary. Article 1 notes that the treaty does not affect free navigation on boundary waters and on Lake Michigan. It singles out Lake Michigan for the definition of boundary water because normally it would not include that Michigan lake, which happens to be really solely in the United States. Similarly, if you look at the Fraser River in British Columbia, although it has major tributaries that cross the boundary, the main stem of the Fraser lies entirely within Canada, and so the river itself is not considered a boundary, nor is the Ottawa River. So it carefully defines what boundary waters are. Taking a close look at Article 2 extends the rights and access to legal remedies for all action taken in one country on boundary waters to citizens of the other. Article 3 agrees that no further obstructions or diversions of boundary waters. This basically enshrines the status quo at that time, so that's why the Chicago diversion never ended up being subject to the treaty. The treaty is about protecting the rights of the other country and shall be made only by the authority of the United States or the Dominion of Canada within their respective jurisdictions and with the approval of the International Joint Commission. The treaty does not provide additional rights in the country he or she resides in if it is in that country where the action is being taken. For instance, if the United States proposes a structure for the production of electricity between its shore and that of an island so that it only blocks half of the river, then the protection in the treaties are for the Canadian interests. They're not for the U.S. interests, whose interests will be protected by the usual domestic remedies. Although under the treaty, Canadians would have access to the same remedies as Americans in America. Furthermore, the treaty does not give an American right to undertake a project in Canada without the authorization of the Canadian government, and vice versa. These are concepts that the public often struggle to understand as they read the treaty and think the rights extend to both countries, which is only the case when the structure or diversion affects both countries more or less equally, which of course is really more often the case. This is especially true in light of Articles 4 and 7. Article 4 of the treaty allows the two nations to enter into special agreements if they wish to be outside the treaty, but otherwise agree that the construction of a dam or structure that may raise the natural level of the waters on the other side of the boundary shall be approved by the IJC. Article 4 also includes the clause which causes it to be cited as the first international pollution treaty in history. The waters herein defined as boundary waters and waters flowing across the boundary shall not be polluted on either side to the injury or health or property on the other. These are unusual words for a treaty signed in 1909 in a period when industrial and urban development were generally first in the people's and in their government's mind, not the pollution caused by the development. However, it's important to note that it's not a general prohibition against polluting, but rather it's about protecting the rights of the people in the other country. Basically, under the treaty, you can pollute the waters on your own side, but only up to a point that it starts to pollute the other side. So, in some ways, the pollution clause is about keeping the peace and preventing a dispute from occurring. Articles 5 and 6 directly outline solutions to resolve the disputes over the Niagara River and the St. Mary and Milk Rivers, and to provide remedies for keeping the peace in the future. Article 5 has since been replaced by a special treaty in the 1950s affecting Niagara, and Article 6 is still in force and is the basis of a 1928 IJC order of approval, although the order itself remains controversial to this day, and the Commission has historically twice split when trying to amend the order. When we think of a peace treaty, we normally think about it being primarily to resolve the matters of conflict between two nations. But the Boundary Waters Treaty also has a provision to resolve conflict, to keep the peace between interests. And in fact, most disputes are more likely based on competing interests rather than being strictly based on nationality. Article 8 of the treaty outlines the priority of use of boundary waters. The following order of precedence shall be observed: uses for domestic and sanitary purposes, uses for navigation, including the service of canals, uses for power and irrigation. However, the treaty is not limited to those three interests, as it goes on to note that the foregoing provisions shall not apply to disturb any existing uses of boundary waters on either side of the boundary. In the modern day context, commissioners have regarded things like environment and recreational boating, for example, to be interests that need to be considered when balancing interests. Recreational boating was hardly a consideration in 1909, but of course today it has become huge. Article 8 also states, the Commission, when considering the effects of structures on boundary waters, shall require as a condition of its approval thereof, that suitable and adequate provision be made for the protection and indemnity of all interests on the other side of the line which may be injured thereby. Again, the treaty is concerned about making sure that the action is in one country does not harm interests in the other country without recourse. The purpose is not to ensure that there is no harm, but that the harm is not in the other country without compensation that could result in a dispute between the two countries. Again, the key concern is to keep the peace. As well, the IJC undertakes investigations and studies for government, invariably on thorny issues such as studying the water levels in the Great Lakes or the diversion of waters for electricity purposes. Article 9 talks about references, like a statement of claim, which we all know initiates the action in the courts. The references are something of the same, as they are formal requests from two national governments to look into and analyze specific matters or problems and make findings and non-binding recommendations for actions to the two governments, by the two governments to resolve specifically. Although the treaty allows for either government to give the IJC a reference, by custom, the governments have jointly given the IJC its reference with exactly the same wording coming from the United States and coming from Canada. It should be noted that under Article 9, we don't have the status of being an arbitration body. Nevertheless, IJC reports are released to the public at the same time that they're submitted to the government, and the force of public opinion supports usually the IJC recommendations. Therefore, there is an implied obligation on both of them to deal with the report in a responsive way. As an aside, it's interesting to note that the treaty is not limited to fresh water, and the governments have sent the Commission references at other times. One of them was on the economic consequences of Point Roberts, located in Washington State, but it is separated from the rest of the United States by a land border with British Columbia. And another example was producing hydroelectric power in the Passamaquoddy tides. The Commission also receives permanent references from the two governments under Article 9. They're set out in specific language in the Great Lakes Water Quality Agreement, in particular, as well, the Canada-U.S. Air Quality Agreement. The treaty does provide in Article 10 for references for which the IJC reports would be binding in arbitration. However, to make such a reference under the treaty, the U.S. federal government would have to gain the concurrence of the U.S. Senate. And we've seen what it takes to get through something through the U.S. Senate. It takes them over 6 months to even approve the appointment of a commissioner in the United States. It's important to understand that the treaty is not self-actualizing. What this means is that in all cases, it's the governments who decide if the treaty is to be invoked, not the IJC and not the public. The governments decide if a proposed project may affect the levels and flows, and if it should be sent to the IJC. The governments decide if the Commission should investigate an issue on a boundary. In the dispute mechanism, there was to be established under Article 12 a permanent Boundary Waters Commission to be styled the International Joint Commission. The word joint being the invention of Secretary Root, as he felt it best described what he and Gibbons envisaged. The commission would be made up of 6 commissioners, 3 to be named by the President and 3 to be named by the Prime Minister. They would swear their allegiance to the commission and specifically not be a representative of their respective countries. It had been Gibbons who persuaded Secretary Root that a permanent commission was the only way to ensure peaceful resolution of those many disputes that were then extant and the inevitable ones to come. It was not a treaty of words only. It included the concept of a permanent watchdog that would give the treaty teeth. The Commission has 2 chairs, an American and Canadian, and they serve simultaneously, working with each other. Uniquely, the U.S. commissioners do not have more votes, nor do their votes carry more weight than those of Canadian commissioners, in spite of the great differences in population and economic activity. I say uniquely because under the model of the United Nations 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes, these and other factors were taken into account, resulting in some countries' votes being weighted more than others. This inconsistency between our Boundary Waters Treaty and the UN Convention, this absence of equality, is one reason Canada and the United States have not signed and are unlikely to sign this 1992 UN Convention. In fact, the commissioners, in principle and by long-standing custom, set out to reach their decisions by consensus, not by formal vote. Although it's important to understand that consensus is not the same as unanimity. Every meeting, every decision requires a quorum of 4. This way, at least, there must be 1 commissioner from the other country to be present. And that's the only way a quorum can be established. And therefore, you can't have one country overweighing the other. As well, under Article 12, the Commission can establish rules of procedure, but they must be in accordance with the principles of justice and equality. The Commission must also ensure that all parties therein shall be given convenient opportunity to be heard. The Commission does this by requiring, for both references and applications, the holding of public hearings. This has become one of the fundamental principles on how the Commission operates. It could be argued that the holding of extensive hearings on the matters before it, allowing the affected public to make its voice known, industries and also levels of government to have their say, helps to keep the peace in the contentious issues. And as described earlier in Article 3, the Commission also makes decisions on applications presented to it by the 2 governments on whether to allow the building of structures on, over, or under a boundary water that affect the natural level flows in either country. The Commission's decisions could be to allow the application, to deny it, or to allow it with conditions. The latter usually is what's happened. An order of approval with conditions is made. The IJC then sets up a control board to oversee it. And the IJC has 15 control boards, all located across this country. When it comes to the Great Lakes, the control bodies involving the structures on the international section of the St. Lawrence River, between Cornwall and Messina, the structure there, and at Sault Ste. Marie and the St. Mary's River, the structures there that control Lake Superior. The IJC also oversees Niagara River and the flow of water there, and it has another control board. So you can see in the first few years, the IJC dealt with the backlog of the thorny issues, and some of those issues never really go away. For example, after the request from Montana to reopen the 1928 order, The Commission held public meetings in 2006 on that request and appointed an administrative task force to find efficiencies in the implementation of the order to benefit both Montana and Alberta. As well, this past year, the Commission had interactions with the City of Winnipeg over the 1913 Shoal Lake diversion from Lake of the Woods that provides Winnipeg its water. The Commission is also involved with many First Nations, and that has not been easy because the First Nations themselves tend to think themselves as a separate country. But we've had a great deal in trying to sort that out with the First Nations, not with a great deal of success, but we're at least trying. Over the last 100 plus years, the IJC has been addressing the problems of the day, the disputes or the applications, all with, I would submit, great wisdom, because the two countries have not come to blows. And some of the most notable successes of the Commission include the 1944 reference on the Columbia River. A major study by the IJC set the stage for coordinated development of water resources in the Columbia River Basin. In 1952, the regulation plan for Lake Ontario and the St. Lawrence River, when the major hydroelectric power project was established on the St. Lawrence Seaway rebuilding. In 1972, the Great Lakes Water Quality Agreement. In that particular agreement, which is considered a model for the world now, issues of water quality were referred to the IJC, and we have been supervising that ever since, producing biennial reports. In 1975, the Garrison Diversion Project in North Dakota, an attempt to bring the water from the Missouri River, introduce it into what would be the Hudson's Bay Basin. And the IJC recommended against that with success. In 1984, the Ross Dam on the Skagit River. Many citizens objected to a proposal by the Seattle City Light Company to increase the height of the Ross Dam in their country because it would flood 2,000 acres of prime recreational land in British Columbia. No wonder they complained. The IJC brought the sides together, and eventually a formula was established that was successful. In 1985, the Flathead River reference, similar problems with the mountaintop removal coal mine in British Columbia that would have polluted the Flathead River and decimated the trout fisheries. In 1999, the Great Lakes water uses, a proposal to ship Lake Superior water to Asia by tanker, ignited a political firestorm throughout the Great Lakes Basin. The IJC recommended policies to protect the lakes from increased consumption of water inside the basin, as well as removals from the basin. These recommendations encouraged action by the Great Lakes states and provinces and helped to develop effective policies. The IJC, under the International Waterways Initiative, have been resolving a lot of disputes themselves on a lake-wide basis, and that has been extremely, extremely successful. The major summation of what the International Joint Commission has accomplished and what the Boundary Waters Treaty has accomplished was perhaps best put forward in a book in 1958 written by authors Bloomfield and Fitzgerald, who reviewed entirely the preceding 50 years and said, the current controversy between Canada and U.S. on the development of the Columbia River Basin has somewhat obscured the fact that for almost half a century, these two neighbors have successfully used the IJC as an instrument for the prevention and settlement of disputes in regard to boundary and transboundary waters. By the time of the 1958 book, the IJC had dealt with 72 dockets in its quasi-judicial role of handling matters where obstructions or diversions could occur. The power to deal judicially with matters is an important role, and in that, the IJC has the capacity to compel witnesses, take evidence under oath, which it's never done, make orders and order costs, and even order compensation. I might add, it cannot be sued, and its orders are non-appealable. Some judges lining the hallways here would probably like to have that in their way of acting. Today, the dockets number over 130. So the International Joint Commission has a credible track record of resolving the peace, solving the disputes, and maintaining order along this vast border, so much of it water. Would there have been peace for all these years without the Boundary Waters Treaty and the IJC? Perhaps. But it must be remembered that more wars have been fought over borders than anything else, and sometimes even the most insignificant of issues becomes an irritant that can escalate to large proportions. It is not the friendly relations which led to the resolution of all these issues that have come and gone in this past century, but rather it is the resolution of all these issues that has led to the friendly relations. The Boundary Waters Treaty was the instrument of peace, the International Joint Commission, the vehicle by which it could be ensured. And for that country lawyer from London, Ontario, George Gibbons, well, after he succeeded with this treaty, he was knighted by King George V 2 years later. It would be Sir George Gibbons, whose name adorned Gibbons Park in London, and whose daughter's family home would become Gibbons Lodge, the home of Western's president. In conclusion, let me again quote from Bloomfield and Fitzgerald. The spirit of international cooperation displayed by Canada and the U.S. in the functioning of the Commission should serve to show other countries that the settlement of the boundary and transboundary water problems can be peacefully worked out between good neighbors. On June the 7th, 2009, the Commission and the governments of Canada and United States held a ceremony on the Rainbow Bridge over Niagara Falls to recognize and celebrate the 100th anniversary of the Boundary Waters Treaty and the enduring peace between our nations. On that occasion, Lawrence Cannon, Canadian Minister of Foreign Affairs, had this to say: Canada and United States have shared and jointly managed the boundary that exists between our two countries without major incident for 100 years. This is no small accomplishment. I don't think you could say this about too many neighbors, so it's indeed remarkable and significant. The Secretary of State of the United States, Hillary Clinton, echoed, "The friendship between the people of the United States and Canada is the strongest in the world. There is no border that is longer and more peaceful. There is no greater trade between two nations. There are so many values that we share in common, and today we celebrate a treaty that helped to make this friendship possible 100 years ago." The people gathered in that celebration stood on just one of 9 bridges at Niagara, each a bridge of friendship. And if they looked far enough through the mist over top of Niagara Falls, they could see between Canada and the United States the Peace Bridge. Thank you.